silence lecture on. We didn't start yet, have we?
Yeah.
Right. We were studying silence as such in evidence, and we covered almost all the common law exceptions and the statutory exceptions to the general rule with regards to the silence. So if I may share the slide, we started by saying that there is a general right of the defendant to stay silent. And if they do stay silent, no one can make adverse inferences. This is generally because of the common law rule or the presumption that there are two presumptions. Firstly, that there is a presumption of innocence. Secondly, no one is entitled to self-incriminate themselves. So you cannot expect the defendant to speak against themselves in a criminal case where the general burden and standard of proof is borne by the prosecution. So it is the prosecution who are to prove the case, and defendant has no duty to admit his guilt. So if the prosecution can prove it beyond reasonable doubt, we would say that the criminal standard of proof has been met and that the defendant can then be said to be guilty. Before that, you cannot say the defendant is guilty. So generally what happens is that defendant has a right to stay silent in police station, in court, and if they choose to do so, either in police station or in court, no one can make adverse inferences. That is the general rule. As you know, the general rule would have exceptions. So the exceptions have been laid down firstly in common law, which is R.S. Parks or R.M. Parks, and finally we have a statute called the Criminal Justice and Public Order Act, 1994. CJPOA creates or allows inferences to be drawn at particular situation, more particularly from section 34 to section 37. Okay, so we covered in details what section 34 is. We looked at the statutory requirement of section 34. We also looked at the common law with regards to section 34. Then we went on to section 35. As we saw in the lecture, it was recorded, it's in the page. So it's on the page. You can go in the YouTube and check the link which is provided in the Facebook page. So we covered section 35 in details. We also looked at the definition, or what do we mean when we say adverse inferences. We also looked at certain circumstances where section 35 does not apply. So section 34 applies to court, and section 34 applies to police station, and section 35 applies to court. Okay, so in the court, whether judge or jury is entitled to draw any inference has been dealt with by section 35. As we know, section 35 was subject to certain exceptions. So when the defendant were under the age of 14, or the guilt is not in issue, or the physical or mental condition makes it undesirable for him to give evidence, at such circumstances you cannot draw inferences in spite of the fact that the defendant is staying silent. So as a matter of general rule, you cannot draw adverse inferences if someone is staying silent. However, you can draw in common law, one, and you can also draw in statute. Okay, the statute is Criminal Justice and Public Order Act 1994. Section 34 deals with outside court proceedings before a trial has actually started, and section 35 deals with after a trial has started, when you can draw inferences. So we have two sections left, which are section 36 and section 37. We'll cover them in details, and we'll also look at the human rights implications of drawing inferences from defendant's silence. So this is today's focal point of the lecture. So in the first half, we'll cover the human rights issues, which are more important when it comes to answering essay questions. So you might have an essay question on inferences and silence, adverse inference and silence, where they ask you whether or not you are entitled to draw inferences, and if you do choose to do so, are you violating defendant's right to fair trial or their human rights protected under the European Convention of Human Rights. Okay. With regards to this, there are certain materials that I will be providing in the photocopy section, as well as I'll be uploading them in the group. So if an essay question comes in, and if you have a basic reading of all the materials, and the provided suggested essay angle answer, you should be able to target 16s or 17s out of 25 if an essay question comes in silence. Okay, so firstly, look, we go slow down. Since we were revising, we were just running over the previous issues. This is where today's class starts. You need to be aware of Lord Justice Devlin's direction to the jury in the trial of Dr. Watkins Adams. So there was a common law rule. That rule was suggesting against the drawing of adverse inferences. So often when it came to whether or not you can draw inferences, say that you cannot. Okay? Why so? Because as Lord Justice Devlin says, it reflects a natural thought of England. So he's saying the fact that you cannot draw inferences from silence is something that goes with the natural common thought of England. And what is that? To put it very simply, what he was trying to enunciate was that, and he quotes, "Ask me no questions, I shall answer none. Prove your case." What this means is that whether or not I'm staying silent is my business. You have your right to answer questions, ask questions, and I have my right to stay silent. So you cannot put pressure or threat onto me, or you cannot compel me to answer questions which would self-incriminate myself. If I'm thinking that the answers are not favoring me, I would rather not answer. So you, in your role as prosecution, prove the case beyond reasonable doubt. It's not my duty. The legal burden of proof is not on me, so you cannot force me to ask questions. I have the right to stay silent. So as Lord Justice Devlin says, and he dramatically puts it, he says there was a horror idea. What was that? It was that when a man is questioned and he's then forced to speak, he might perhaps condemn himself out of his mouth, and then everyone would try to suspect the accused. So whenever a suspect was being charged, that horror idea prevented the defendant from speaking. So defendant rather chose to stay silent, which was the safer option, because in any case, the state is always better equipped to prove a case. They have within their disposal the police, the detective service, and the entire criminal justice system within their reach and within their use. So it would rather be the prosecution would prove a case, and the defendant can definitely therefore choose to stay silent. Okay. Now, as we know, why defendant could stay silent was also dependent on the presumption of innocence. If now CJPOA and the common law provisions are allowing inferences to be drawn, you need to then decide how much the concept of privilege against self-incrimination is sacrificed or is being violated. Okay. So that should be your focal point of the essay question. And obviously, the first couple of paragraphs should always be full of references and quotations and ornamental writing, which would put it to the examiner a view that you have studied some academic reports with regards to silence and not just the statute and common law cases. Okay. Focus on this line. A person should not be compelled on pain of punishment to expose themselves to the risk of self-incrimination. So the concept of privilege against self-incrimination says you cannot force someone with threat, with law, with legitimate expectation that he has to speak. Okay? If he is thinking that if he says something that would go against him, he would rather stay silent. He must not self-incriminate himself. In a case, the prosecution would have its prosecution theory and the defense would have its defense theory. The defense theory is never aimed at helping the prosecution case. So it's an adversarial system in the United Kingdom where both parties would hire a lawyer and the both parties' lawyer would then try to prove their significant point, and none of the parties are to help each other with their case theories. This lies at the heart of the privilege against self-incrimination, that even if I've done it, you are to prove it. It's not the defendant who would admit guilt. It is the prosecution who would prove guilt beyond reasonable doubt, and hence the defendant would be presumed to be innocent. As a result, you cannot draw adverse inferences from defendant's silence because he has this right to not self-incriminate himself. But as you know, that's the general rule, and it would always have exceptions. So the exceptions were laid down in common law or through statute, and allowing inferences to be drawn is directly against the concept of privilege against self-incrimination, and there would definitely be therefore overlap when you're allowing inferences to be drawn. So there is this one set of rules, academic writings, and common law provision that says no, you cannot draw inference from defendant's silence. Then you come with the common law exception, and in 1994, 20 years ago, you make a statute which says yes, adverse inferences can be drawn. So they are directly conflicting school of thoughts, and it needs to be seen where the check and balance lies, so that you can draw inferences, but at the same time you do not someone's right to fair trial or his human rights. Okay. But the parliament was obviously cautious when they were drafting the Criminal Justice and Public Order Act. How so? Because they introduced the concept of caution. Remember, we were studying last day that even before Section 34 or Section 35 is activated, so what happens when Section 34 and 35 is activated? Can you draw inference or can you not? Yes, you can draw inference when Section 34 and Section 35 applies. But before they do apply, you have to caution the defendant. With regards to Section 35, we checked last class. The caution is in the line that, look, son, we have reached a phase where it's the final stage of the trial. This is where you definitely have to speak. If you have something to say to the court, this is where you definitely speak, because the juries will be retiring soon, and once the juries retire, they return with a guilty verdict. We have nothing in our hand, so you better speak. If you have anything to say that you didn't do it, or you're not at the spot, or you're not involved in the crime scene, you have to say it now. If in spite of that caution he stays silent, that is almost like a suicide. So why would you not allow drawing of inference in spite of the fact that he has been cautioned? Look, this is the final stage of the trial. This is where you have to speak. Okay. Obviously, the concept of caution was introduced so as to better protect human rights. Okay. And the caution goes in the line, you do not have to say anything. So the language or the wording of the caution would definitely start with, You don't have to say something. You don't have to say anything, but this is where we prefer you say something, right? Whenever the police is cautioning under section 34, or whenever the judge is cautioning under section 35, they start with, you don't have to say anything. Why do they do so? Just to reflect the previous common law. What is the previous common law? That they have right to stay silent. One. Why? Because there is a presumption of innocence. Why? Because there is a doctrine of presumption, against self-incrimination. So you're not to self-incriminate yourself. On that basis, when they are saying, the judiciaries and the courts and the police and the executive officers are saying, you do not have to say anything, this is just a reflection of what the previous common law was. Okay, so the lining or the wording or the phrases that are used in caution are developed very carefully, not so that human rights are not violated, and so that the previous doctrine of right to stay silent stays intact. You have to understand this part. We were talking about this the last day as well. Well, it does put pressure on the suspect to speak. So when you're cautioning, you don't have to say something, but this is the last stage, you better say something. It's definitely a pressure. And you're also saying, if you don't speak, the juries and the judges are entitled to draw inferences as they see fit and proper, right? So it's a pressure on the defendant to speak. But do they have to speak? Is it an issue of compellability, or is it an issue of obligation? Do they definitely have to speak? No, you are just inviting them to speak. So whenever a court says you need to do something and you don't do it, what takes place? A contempt of court. So academic writings after the enactment of this Criminal Justice and Public Order Act clarified that both section 35 and section 35 are not contempt sections. So they are not creating obligations. It's still defendant's choice whether they want to speak or they don't want to speak. So they do not necessarily have to speak, and if they do not speak, they're not disrespecting, disobeying, or violating the court. Okay, they still have this common law right to stay silent in spite of the pressure that is put on them by the Criminal Justice and Public Order Act 1994.
But sir,
yeah,
যেহেতু স্যার না বলার কারণে ওর উপর একটা ডিগ্রি ইনভার্স এফেক্ট পড়ছে, সো আলটিমেটলি তো ওকে বাধ্যই করা হচ্ছে বলার জন্য।
Well, that is what the essay would demand you an answer from the students, that whether or not there is a definite violation of human rights, and you have to be very careful when you answer that. So you just have to take this approach. You take this approach and state the common law at first, and then say there might be an overlap. If there are conflicting school of thoughts, then you introduce the CJPO in 1994, and then you look at particular cases to see in those cases what was being held as to whether or not there was a violation of human rights, right? So that's not a straightforward answer whether or not a violation takes place. Some cases it may, some cases it may not. Do you people know what the Strasbourg Court is all about? Is the European Court of Human Rights. Basis of conviction. Yeah, there would have to be other supporting evidence. So those concepts are there as well, as we say from the Condrons and other cases, right? So 1998 was the year where English judiciaries were given significant power by the Parliament. What was the act called? The Human Rights Act. The Human Rights Act is significant in many ways because to particular sections it overpowers the judiciaries. There is this one school of thought that says the judiciaries are now being enjoying power over and above executive and public body in scrutinizing their decision when it comes to human rights related issues. There was this section 6 in the Human Rights Act that says that any public body, and a public body includes a court or tribunal, any public body must act in a way which is compatible with the European Convention of Human Rights. So the European Convention of Human Rights protects various categories and kinds of human rights through various articles. And in English domestic courts, whenever a question of human rights arises, Section 6 makes it unlawful the decision of public body if the decision is not in compatibility with the European Convention of Human Rights. So after 1998, adverse inferences and from this defendant silence, the concept of adverse inferences have significantly changed, because it is now unlawful if a court or tribunal violates defendant's right to fair trial by holding the defendant guilty from his silence. Look at these two lines. Read these two lines and think where the test has shifted after the drafting of the Human Rights Act. So should you draw inferences so that suspects face natural consequence of their suspicious behavior, or should you draw inference so that you are just encouraging the suspect to speak? It's the later part, right? So you cannot say you're guilty just because you're silent. You can just say, please cooperate if you're not guilty, or if you're guilty, even if you're not guilty, just speak about it. So do not be silent, at least say something, so that if you're staying silent and if you're being allowed to now draw inferences, the suspect would have an added encouragement to speak about it and not just stay mum in the court. But as Rifat pointed out, even if that is the case, is it not an added pressure where by allowing to draw inference, you are now going against the concept of the privilege against self-incrimination? It is in a manner a tension with regards to the principle of the privilege against self-incrimination. There is this added pressure now on the previous existing common law doctrine of the privilege against self-incrimination. This is more important after the enactment of the HR 98, and HR 98 does allow to enforce the articles of the European Convention directly in the domestic courts. So one of the articles is Article 6, which is at the heart of the subject, crime and evidence, right? The defendant's right to fair trial. So even if the defendant is 100% guilty, you take him through a process which you'd take any other defendants through. So you cannot just hang him up by saying, look, we've got concrete evidences. You take him through a proper trial process. This is the defendant's right to a fair trial. Even if he's 100% guilty, and even if there is just single evidence that shows he's not, which he might not, right? You have to allow that evidence to be put into the trial, because a defendant must have a right to fair trial. So the European Court of Human Rights, the Strasbourg, intervenes often when the UK courts fail to protect the human rights. So when the United Kingdom domestic courts fail to protect the rights and freedoms of the citizens of the United Kingdom, and if the United Kingdom citizens choose to take the litigation to the European Court of Human Rights in the Strasbourg, they can definitely do so. And most often, as it appears, if you are willing to go that far to the Strasbourg court, it means you do have a really strong case, because there is a significant cost involved. So often in those cases which goes to the Strasbourg court or the European Court of Human Rights, there is a decision in favor of the claimant, because those are like serious issues where the claimant or the appellant was actually willing to pay a significant amount of cost, because the lawyer might have thought, okay, this is an area where right to fair trial is definitely violated. So European Court of Human Rights has declared that privilege against self-incrimination and right to silence lie at the heart of the Article 6 of the Convention. So if privilege against self-incrimination is at the heart of Article 6, and if you are having disregards to the privilege against self-incrimination, are you not just snatching or killing away the heart of Article 6, and therefore are you not ending up violating Article 6 of the Convention, right? Because if you take away the heart, the doctrine goes away, and ECTHR has declared that yes, if you are violating the privilege against self-incrimination, you are in a manner violating Article 6 of the Convention, right? However, European Court of Human Rights do acknowledge the fact that both these presumptions or the privileges or the right, they're not absolute right. So they're not 100% right. If in certain circumstances you do need to depart from those rights, you do depart. There's no problem, right? But they are the check and balance and the conditions that need to be satisfied before departing from the general or common law principles need to be sufficiently strong enough for you to depart. So although it lies at the heart of Article 6, still both this privilege against self-incrimination and this right to silence is not an absolute right. You can, if you want to, violate these rights if it's in the greater interest of public policy or whatever. So whether or not Article 6 is violated should be determined in the light of circumstances. So it's not a straightforward answer. It would depend from case to case. It would vary from case to case. It would depend upon the circumstance of each of the cases. How? Check this part. The evidence that the prosecution would want to adduce, or the question that the prosecution is asking, should be a question that is very important. Okay, so it depends on the importance of the questions, depends on the importance of the evidence. So if the questions are just mere questions out of 1,000 questions and the defendant chooses to stay silent, the defendant can do so. However, if it is really required that he answers and he's trying to avoid the answer just because it might go against him, or the answer is such that it would not stand up to investigation because it's a weak answer, it's a lie, it's a concoction, it's fabrication, and it would not survive a proper cross-examination, then Section 35 does allow to bring or to draw inferences against that silence, right? But as some of you are saying, silence cannot be the sole basis of conviction. So in an essay question, do highlight the part that national court cannot conclude that accused is guilty merely because he chooses to remain silent. There must be lots of other supporting evidences. So if the prosecution evidence have established up to 70%, let's say for example, that he was guilty, and on top of that the defendant is staying silent, you can make adverse inferences. But if there is no prosecution case, if there is no prosecution evidence, you're trying to only convict the suspect on the basis of silence, you should not be doing so, right? This is another part. So where prosecution had so little evidence that there was no case to answer. So if the evidences are strong and if you have proved almost or you've established your case theory well, then I'm expected to answer. If you don't have a case theory, if you don't have a case established, if you don't have sufficient evidences against me, why should I be answering? Okay, so when the burden is on the defendant to speak, you need to consider also what evidences the prosecution has adduced before they're asking the defendant to speak about the questions that they're asking. Even after you are being allowed to draw adverse inference from defendant's silence under section 34 or section 35, there was this Cohen direction we looked at in the last class. In the Cohen direction, you almost literally say everything. Firstly, that look, the burden of proof is on the prosecution. So defendant is not expected to speak even. If the prosecution has brought a case, they must prove it. What does that mean? That means is that if the prosecution are to prove, defendant can definitely choose to say silent. Secondly, there was this previous two doctrines of privilege against self-incrimination and the right to stay silent. And if the defendant chooses to stay silent, you should not be able to draw inferences. Okay? Then check whether or not the caution has been provided. So there are like lots of filtering mechanism that goes on before you are allowed to draw adverse inference from defendant's silence. And with these directions, with this judicial direction to the jury, not to convict the defendant solely on the basis of silence, and with regards to burden standard of proof and the right to stay silent, the judiciaries are trying to adopt a human rights friendly manner where they're trying to protect the interests of the defendant. Also, even though the fact that the CJPOA 1994 does allow to draw adverse inferences against through defendant's silence. Okay, so যদিও CJPOA 1994 থ্রুতে আপনি অ্যাডভার্স ইনফারেন্স ড্র করতে পারছেন, সো জুডিশিয়ারিজরা 1998 এর পর হিউম্যান রাইটস অ্যাক্ট আসার পর সবসময় মাথায় রাখছে যে আমাদের বিভিন্ন ডক্ট্রিনস আছে এভিডেন্স লতে, সেই ডক্ট্রিনস গুলো যেন ভায়োলেট না হয়। সো দ্য বার্ডেন এন্ড স্ট্যান্ডার্ড প্রুফ যেটা প্রসিকিউশন বিয়ার করে, ডিফেন্ডেন্টের যে রাইট সাইলেন্ট থাকার, ডিফেন্ডেন্টের যে প্রিভিলেজ নিজেকে ইনক্রিমিনেট না করার, এই জিনিসগুলো সবকিছু মাথায় রেখে ওরা ফাইনালি সাম আপ করে একটা ডিরেকশন দেয় যে হ্যাঁ jury, as a member of jury, you can draw inference, but যখন inference draw করবে একটু কেয়ারফুল থাকবা, because defendant-এর একটা কি রাইট আছে, রাইট টু ফেয়ার ট্রায়াল। প্রসিকিউশনের যেরকম রাইট আছে একটা মামলা প্রুফ করার, ডিফেন্ডেন্টের সেরকম রাইট আছে একটা ফেয়ার ট্রায়াল power. So even if he is guilty, even if he is not guilty, he must go through a fair process of trial. So this is the essay guideline, and I would provide almost like 10 to 12 pages of materials today on the page. You have a read at them, and you do have a look at the essay angle of the silence topic, which you might not as well, because this is not something that often appears in the exam. Obviously, when the March arrives, there will be a March newsletter, and I'll be able to better advise you which essay angle you should definitely be preparing and which chapters you should be focusing upon for the essay purpose. But for the time being, have a read as to how the drawing of adverse inferences can be in violation of the European Convention of Human Rights, and hence how after the enactment of HR 19, how the scenario has changed, where the judiciaries can and where they cannot draw adverse inferences from defendant silence. Right, so we move on to more interactive sessions. Now that was an essay question angle, and we now focus again on the problem question, and we finish today two sections, section 36 and section 37. Right, so what is the general rule? Can the defendant stay silent? Yes. And do they have exceptions? Yes, at common law and also in statute. What is the statute? Criminal Justice and Public Order Act 1994. How many sections are allowing to draw your inferences? 4. 34, 35, 36 and 37. 34 is outside court. 34 is during the phase of the proceedings, and we have not looked at section 37 and section 36. So let's focus on section 36 first. This silence is about objects or substances or marks found. So obvious example is where the allegation against you is murder and there's like blood stain in your clothes, or you have a gun with you, or if the charge is handling stolen goods, you do have the stolen goods with you, right? So you have objects, substances, marks, stains, those at your clothes, at your disposal, right? So, and then you're being asked questions, where did you get this? Where did you get the gun? Where did you get the stolen goods? And why is this blood in your clothes? And then you choose to stay silent. Can the jury then think, okay, this guy is staying silent because he committed the murder, therefore the blood is in his clothes, and therefore he is not speaking about it because Choremon police. ঠিক আছে? So এজন্য section 36 থেকে আপনাদেরকে question যখন আসবে section 36 or section 37 এর লাস্টের পার্টটা আসবে যে এই substances, objects, marks আর place এর একটা mainly focus থাকবে 34 আর 35 এর উপরই, কিন্তু লাস্টের দিকে 36 37 ইস্যুগুলো আপনাদেরকে আস্ক করতেও পারে। ঠিক আছে? So we'll go through this fast. However, before section 36 can be activated, and what happens if section 36 is activated? Can you draw inference or can you not?
Yes.
You can draw inference if section 36 is activated. Before it is activated, certain conditions would need to be fulfilled. Firstly, inference can only be drawn from the objects, marks or substances if the following conditions are met. Condition 1, under arrest. Before arrest, if you ask in question, where is this gun from? Where is this goods from? Why do you have the pack of heroin with you? Before arresting him, if you ask this question, section 36 application just goes away. It cannot apply if the defendant is not under arrest. So first thing that you need to satisfy is defendant is under arrest. The suspect has been arrested and then questioned. Okay? Condition 2, object, substance or mark was found at the place of the arrest. So it's not before or not after. Where he was arrested, he was found with object, substance or marks, and those objects, substance or mark was in his possession or in his person or in his clothing or in his footwear. So if the allegation is that you have been involved in a grievous bodily harm or section 20 charge, and the allegation is that you kicked the victim at his face, severely wounding or bleeding him, and you are being found at the place of the arrest with blooded shoes, blood-stained shoes, then section 36 would apply. So first condition is what? He must be arrested. Second condition is what? The object must be found at the place of the arrest. Is it kept beside him? Is it kept like 30 feet away from him? Can you? No, it must be in his possession, or it must be on his person, or on his clothing, or on his shoes. So it must be really, really there. It's a straightforward situation. It cannot be that you're in one station and there's this bag in another station and you're being asked, what is this bag about? So the bag must be found with him. He must be carrying that bag in person or in his possession. Any questions? It's easy. Condition 3. Three person, either the constable or the customs officer or the excise officer, what are they thinking? They're thinking that the presence of the object, substance of the mark can show causal connection with the participation of the offense. So straightforward scenario, a mobile has been stolen and that mobile has been found with you. So does that object not lead an causal indication that you committed the theft? Get my point? Someone was injured and there was blood in your clothes. So that is a causal indication that since you are being found with a bloodstained cloth, you were the person who was involved. Can you ask those questions before he's arrested? No, they must be under arrest. And can it be at any other places? No, it must be at the place of arrest. Can the goods, objects, substances be not with him? No, they have to be with him. So it's like a একদম হাতে নাতে ধরা পড়লে যখন সাইলেন্ট থাকবেন তখন অ্যাডভার্স ইনফারেন্সেস ড্র করা যাবে নাকি যাবে না সেটা দেখছি কোথায় সেকশন 36 এ। Then comes the special warning. This is designed to make it compatible with the European Convention of Human Rights. What is the warning? The accused must be given a special warning and it would inform him what? That the accused must be asked to account for the presence of the object. Bolbe je, look son, you have been found that the charge is a theft of a mobile phone. That particular mobile phone is found in your pocket and we are now warning you that we might be asking you about this. He must be given a warning. Yeah. So the test is accused must be informed of the belief. What belief are we talking about? We're talking about this belief that there's a causal connection. We believe, we means constable, customs officers or excise officer. We believe that since you stole the mobile, it's with you. So the presence of the mobile phone in your pocket or in your bag is an indication that you did it. So the constable, customs officers or the excise officers, they would have to warn. We found you with the mobile phone and we think you have stolen it. So that warning must be given to him. And finally, failure to account. The accused must then fail to account after all the warning and the information about the presence of the mark, object, or substance. So let's take, for example, a drug trafficking case. They say that we're suspecting you for transferring or trafficking class A drug, okay? And a pack of heroin has been found in your bag. Let's now think the defendant is really innocent. So he doesn't know. He has been trapped. He has been set up, okay? So he has been set up with a bag of heroin. So he doesn't know that heroin is there in the bag. So if he had not known, would he now not speak up? Because he's been given a special warning. We're looking for a suspect who has been involved in heroin trafficking, and in that heroin trafficking, we found that the particular bag of heroin is found in your possession, and we suspect that since you stole it or you're trafficking it, you are having the heroin in your person or in your possession. So if you're genuinely innocent, common sense says what? You'd speak up. Would you not speak up? Right? So even after all these warnings and communication of the belief that the presence of the subject, object, or substance, object, or mark is leading to suspicion or belief by the police officers that you are involved in the crime, even after all these warnings, if you choose to stay silent, should you not be allowed to draw inferences? That is the test. So you have been warned particularly, and you do not take care of the warning. You go ahead and stay silent, and from your silence later on, if you try to rely on it in the defense, then adverse inferences can be done. Let's just revise. Firstly, is it about participation in the crime? Think. Is it questions about participation in the crime or questions about why some substances were found? জিজ্ঞেস করছে যে আপনি কি ক্রাইম করেছেন নাকি কি বলছে জিজ্ঞেস করছে এই অবজেক্টগুলো কেন আসছে এখানে। The question is regarding to the objects, substances or marks. Who can question? Who can question? A constable, customs officer or an excise officer. When can he question? Should he be first arrested or not arrested? Arrested. So first he has to be arrested. the object, there must be a proximity between the object found and the location of the suspect. So it must be found beside him. It must be found in his possession, in his person, clothing or footwear. Now, you have to understand the word possession. It can be used or interpreted widely. So if some substances are found at your home, is it not in your possession? Are you not controlling it? So it's in your control, it's in your possession. Not necessarily you have to carry it. So it can be at your place, it can be at your office, then it would be held that it is in your possession, right? And if it is found in person, well and good, there's no question. With regards to clothing and footwear, this would be stains, blood stains and marks rather than actual substances. So the case is someone was stabbed and then in your footwear, that is in your shoe, you hid a knife. And the police found that knife at the place of arrest and then asked you and warned you, we are thinking that you stabbed the guy who was just stabbed 50 meters away, right? And then say, if you choose to stay silent, we may draw adverse inferences. In spite of all this warning, you say nothing. If you're really innocent, you should have spoken, okay? But this is against the right to remain silent, the doctrine. But why should it not be just a prima facie violation of human right? Section 36, because there are lots of warnings and exchange of information that goes on. So we're trying to encourage the defendant to speak rather than just trying to hold him guilty. This is very easy. Section 37, presence at the scene of the crime. So the defendant was present at the scene of the crime. So if it's an arson, একটা বাড়ি যদি জ্বালিয়ে দেয়, defendant ওখানে ছিল, একটা মার্ডার যদি হয়, defendant was present, একটা যদি একটা brawl হয়, কারোর মধ্যে মারামারি হয়, গ্রুপটার মধ্যে defendant ছিল. And when being asked why were you present, look, the defendant failed to answer. It's asked about the present. Why were you present? It's not about the substance anymore. It's about his actual presence. Again, like section 31, there's a condition. So it would be rather 37. What is the first condition? That there was been arrest first. So before arresting, you cannot say যে তুমি ওখানে ছিলা কেন. Now, the next test is the defendant was found at a place the offense was alleged to have occurred when, at, or about the time. So when the offense took place, you were there. Not like that you were there before 2 days or 2 days after the incident. So it is at or about the time of the incident, you were there. That's the second condition. Thirdly, there is again a belief by the constable, customs, or the excise officer, what that we are believing, we are suspecting that you were present there because you were involved in the crime. So their belief that defendant was present there at the scene because he was involved with the crime. As a third criteria.
Section 37.
As these are still section 37, sorry. Yes. Yeah, again, the special warning must be given. To whom? To the suspect. By whom? Constable, excise, or duty officer. Yeah, custody officer. And what is the special warning about? About their belief. What is that belief about? Participation of the suspect. With what? With regards to the crime. As a result of what? Because of the presence of the defendant at the scene of the crime. The accused must then fail to account why he was there. So after all the warnings are given, the defendant remains to stay silent. Can you draw inferences? Yes, you can. Okay, just quickly revise section 36 and section 37. What is section 36 concerned with? Objects, substances, or marks. What is section 37 concerned with? Presence of the defendant at the scene of the crime. Both of the section 36 and section 37 activation requires certain conditions to be fulfilled. What is the first condition? Under arrest. What is the second condition? It depends whether it's section 36 or it's section 37. With regards to section 36, it says that object substance was marked at the place of the arrest. And with regards to section 37, it says defendant was found at the scene at or about the same time, or at or about the time of the incident. Then the third requirement is same, is the presence of the causal suspicion. Since the object was found in 36, you were guilty, or since you were present under 37, you were actually participating in the crime. That is the belief. Who is believing it? The constable, customs, or the excise officer. Why? Because of the presence of the subject or the presence of the defendant. And then comes the warning. Who warns whom? The constable or the duty officers warns the suspect that we will now make adverse inferences if you stay silent. And then what the defendant have to do? He would have to stay silent. And so after all these warnings, if the defendant chooses to stay silent, then you can hold or think that he was genuinely involved in the crime. But that cannot be the sole reason for the conviction. There would have to be other supporting evidences by the prosecution witness.
So in section 36, the place should be the place of arrest, and in section 37, it should be the
Place of the crime. Yeah. Do we take a break or do you finish it just overall? We might be running out of time though. But this would be interactive since it's a problem question. Do you genuinely want to break? Just finish up. Just finish up. Okay. Yeah. So we start reading together. So these are the two persons, David and Sid. What is the charge? Aggravated arson. So the charge against them is that they burnt down a place. Is it Crown or Magistrate Court? If there is Crown Court, what should come into your mind? Judicial direction to the jury. So there's this co-on direction. Remember, with regards to section 35 and section 36, or section 34 even, there is this co-on direction that you must warn the jury that the burden is in the prosecution, blah, 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 blah. Those kind of things. So what is this charge? David and Sid deliberately set fire. Who are the owner? Both of them. So defendant number 1 is David, defendant number 2 is Sid. They're both being charged with aggravated arson of burning down a nightclub or a pub that are being owned by them as well. That is being owned by them. So they're the owner, and the allegation is that they have burnt it. So the prosecution is saying the motive, the intention to burn that house came from the fact that you'd get substantial insurance cover if you burn down your place. So the charge is you burn down your own place so that you can get some money out of it through the insurance cover. Read this paragraph. This is an issue of confession. We dealt with this previously. So we're not going to look at this. So these are like oppression, unreliable, making it unreliable by saying things are done, by putting the defendant under pressure to speak up. And then the David confessed. Here comes the issue of silence. Look, so David and Sid are being jointly charged, aren't they? So they're both under the acts of being held guilty, and he was being questioned by the who? Sid. So Sid was now being questioned by the police. Where? And he refuses to answer. Sorry? Yeah, from the advisory solicitor. That will come later. So where is this silence taking place? Court, police station. Which section applies? Section 34. Very good. Very good. But section, yeah, good. Well done. Now, is he trying to rely on it in his defense? Sid intends to testify in his defense. Look, Sid is trying to put a different theory. He's trying to say, at the time of the fire, he was home. So he's claiming an alibi. He was not present during the scene of the incident. Should he not have spoken that when he was being questioned? Sid claims that he did not mention this fact when questioned by the police because his solicitor had told him not to answer any question. So remember, we looked at the at some of the cases with regards to section 34. অনেকগুলো cases দেখেছিলাম, 20টার মতো cases. Solicitor বললেই চুপ থাকলে হলো? Solicitor উপর বিশ্বাসটাও তার ঠিক থাকতে হবে, এবং there was a genuine reason why he believed in the solicitor. So solicitor তাদের সবাই বলবে solicitor আমাকে চুপ থাকতে বলেছে, আমি কথা বলবো না। So solicitor চুপ থাকতে বললেই কিন্তু আমি সাইলেন্ট থাকতে পারবো না। Still inferences can be drawn. আচ্ছা, আমরা ডিটেইলসে দেখছি পরে। David does not intend to testify in his defense. Can he do so? David testify করতে চাচ্ছে না ডিফেন্সে, কথাই বলবে না। পারবে এটা? পারবে না? Defendant has the right to stay silent. He does not want to testify. কোন সেকশন? কোথায় testify কোথায় করে? Court. কোন সেকশন? Section 35. So Sid কোথায় চুপ থাকতে চায়? Police station. It's before the proceedings have started, right? That's an application of section 34. And David কোথায় চুপ থাকছে? Court. That is an application of section 35. So can he do so, David? Yes, because this is the general rule of right of defendants silence. What is it to based on? দুটো জিনিস, privilege against self incrimination আর একটা presumption of innocence. এটার সাথে কানেক্টেড কি? burden and standard of proof. কে প্রুফ করবে কেস? প্রসিকিউশন। কোন স্ট্যান্ডার্ডে? বিয়ন্ড রিজনেবল ডাউট। তাহলে সাইলেন্স থাকলে কি আমি গিলটি? সাইলেন্ট থাকলে কি আমি গিলটি? না। দ্যাটস দ্য কনসেপ্ট। আচ্ছা, তারপর আমরা ডিটেইলসে দেখছি আরো। আচ্ছা দেখেন, এখানে একটা ইস্যু যাচ্ছে আবার। কি বলছে? প্রসিকিউশনের থিওরিটা কি? একটা ব্লো টর্চ আর পেট্রোল দিয়ে আগুন দেওয়া হয়েছে। একটি ব্লো টর্চ আর একটা পেট্রোল দিয়ে আগুন দেওয়া হয়েছে। এখন দেখেন, ডেভিডের বাসায় যখন গিয়েছিল কি হয়েছে? কিন্তু পরে So police found the equipment. Can you say that there is this presence of objects and substance at the possession of the defendant when he was arrested? ওই যে সেকশন 36 এর ইস্যুসটা, যে সাবস্টেন্স, মার্কস, অবজেক্ট যদি আপনার কাছে পাওয়া যায় যেটা ক্রাইমের সাথে ইনভলভ, দেখেন ওর পাশে কি পেয়েছে, দেখেন যা প্রসিকিউশন বলছে মোটামুটি তাই পেয়েছে না? তাহলে এটা কি? তখন পুলিশ অফিসারটা একটা ডাউট হতে পারে না যে এটা দিয়েই সে ক্রাইমটা করেছে? ঠিক আছে, ওই যে belief of the constable, that the constable believes that a presence of this substance would indicate a participation towards the crime. পড়লাম না সেকশন 36 একটু আগে, ওটা হতে পারে। এই দেখেন, subsequently re-interviewed in the presence of his solicitor. On this occasion he refused to answer any question. So ডেভিডকে যখন পরের বার যখন আবার ইন্টারভিউ করেছে, ও কিন্তু ওখানেও সাইলেন্ট ছিল। Was he arrested? Yes, he was definitely under arrested. In particular, he refused to explain why he was both at the lounge and why the equipment was found. Eta ki bolen to? Why he was present in the lounge. This is an application of section 37. ওই যে presence at the scene of crime. আর এটা কি? এই যে তোমার কাছে এই জিনিসগুলো কেন পাওয়া গেল? section 36. আচ্ছা দেখেন, আমরা একটু আবার রিভাইজ করে আসি। As fast as possible. 36 is concerned with objects, substances, and marks. So if you're being found with objects, substances, and mark, and you do not have a good enough explanation, আমি কি draw করতে পারবো? Adverse inferences. And 37 is concerned with presence of the defendant at the scene of the crime. How many conditions are there? 5 conditions. Condition number 1 is what? Arrest. Condition number 2 is what? ওই যে presence and participation ওখানে পাচ্ছে ওই জিনিসগুলো, object, substance, mark অথবা আপনার presence. Condition number 3 কি? Belief, the causal link. Condition number 4 কি? Warning. And condition number 5 কি? Defendant চুপ থাকছে. Let's go back to the question. So where did the fire take place? Alleged incident কোথায় হয়েছে? ক্লাবে। ডেভিড ওই রাতে ক্লাবে ছিল? ছিল। ওকে জিজ্ঞেস করছে পুলিশ অ্যারেস্ট করার পর, কেন ছিলা? বলছে কিছু? বলে নাই। কেন বলে নাই? বিকজ সলিসিটর ওকে চুপ থাকতে বলছে। আচ্ছা, ওর বাসায় কি জিনিসপত্র পেয়েছিল? তার মানে ওই সাবস্টেন্স, অবজেক্ট, ওটা কি ওর পজিশনে ছিল? পার্সনে কিন্তু ছিল না, পজিশনে কিন্তু ছিল। ইট ওয়াজ ইন হিজ হাউস। সেখানে কি আসতে পারে? সেকশন 36 আর presence of the scene at the scene section 37. আচ্ছা, ডেভিড যে কোর্টে চুপ থাকছে সেকশন 35 section 35 court in the proceedings, আর এই যে সিট যে এই পুলিশ স্টেশনে চুপ থাকছে ওটা সেকশন 34. সো দেখছেন কনফেশনের কোশ্চেনের সাথে এরকম মিলিয়ে আসতে পারে, অথবা সেকশন 34, 35, 36, 37 একটা সোল আসতে পারে। লাস্টে আপনারা যারা 60, 70 স্টার্ট করছেন, those of you who are aiming for higher marks, they can go for obviously last one page of a human right discussion. So just write couple of cases. Murray, Condron, যে whether there is violation of article, say ওই যে ornamental কথাবার্তাগুলো, যে there is this presumption of হ্যাঁ লাস্ট একটা পেজ আপনি বলবেন যদিও আমরা সিজেপি এর আন্ডারে অ্যাডভার্স ইনফারেন্স ড্র করতে পারি, অনেক সময় এসিটিএইচআর কি হোল্ড করে যে না আমরা পারি না, কারণ there is this violation of human right or violation of two basic presumption of innocence or presumption of no guilt. You have presumption of innocence and privilege against self-incrimination, which says or which stays at the heart of the Article 6, and Article 6 is one of the very core articles of the European Convention of Human Rights, যেটা ভায়োলেট হয়ে গেলে কিনা ডিফেন্ডার্স রাইট টু ফ্যাক্টর পুরোপুরি জেপারডাইজড হয়ে যেতে পারে। ঠিক আছে, আচ্ছা, লেটস লুক এট দ্য আনসার নাও। I've provided in the photocopy কিন্তু নিয়ে নিন, অথবা আচ্ছা সফট কপি দিয়ে দিন। Obviously it's a huge answer, কিন্তু আপনারা তো এতটুকু লিখতে হবে না, জাস্ট আমি বেশি দিয়ে দিয়েছি যেন মানে কমতে যেন কিছু একটা থাকে আর কি। ঠিক আছে, আমি কিন্তু আবার আপনারা তো অনেকে আসতে পারতেছেন না হঠাৎ জন্য, আমি কিন্তু সফট কপিস গুলো পোস্ট করছি। ঠিক আছে, এটা নিয়েছেন কালকে যে সফট কপিটা দিয়েছিল? হ্যাঁ, এটা কনফেশন সেমটা। আচ্ছা, জাস্ট একটু রিভাইজ করেন। 34 কোথায়? পুলিশ স্টেশন, আউটসাইড কোর্ট প্রসিডিং, মানে বিফোর ট্রায়াল ইটস টেকিং প্লেস। 36 কোথায়? 36 at the place of the arrest, ওর কাছে যদি পায় তো পুলিশ থানায় এনে কোয়েশ্চেন করবে। কশন দিতে হবে না? সো এখানে দেখেন কশনটা বুঝেন কিরকম হয়, জাস্ট ল্যাঙ্গুয়েজটা বুঝেন। কশনটা কি বলবে যে কি ধরনের অফেন্স ইনভেস্টিগেট করা হচ্ছে, প্রসিকিউশনের ধারণা কি, কে করছে ওগুলা, আর বলা যে we're suspecting you were involved in the crime, and if you choose to say silent, court may draw proper inference and that the interview is recorded. So আমরা কিন্তু এই জিনিসটা কিন্তু পরে ট্রায়ালে আসবে যে আমরা তোমাকে কোয়েশ্চেন করেছিলাম এবং তুমি ভলান্টারিলি চুপ ছিলা, কারণ ইন্টারভিউটা কিন্তু রেকর্ডেড হচ্ছে, ঠিক আছে? সো ইফ ইউ স্টেইং সাইলেন্ট, একটা আপনাকে কোয়েশ্চেন করে যাচ্ছে, বলে যাচ্ছে, ওয়ার্নিং দিয়ে যাচ্ছে, আপনি চুপ আছেন, তার মানে কি there is an indication that you were involved in the crime. আচ্ছা, let's look at the answer. Consider Sid's silence when questioned by the police. কোন সেকশন আসবে? Section 34. So what is Sid trying to claim? Alibi, that he was not present at the scene. Was he being asked question regarding this, to where were you? Did he say it?
No.
Did he later on try to rely on it as a defense? That is the sole requirement of section 34. And just give me one moment. So check this, revision হয়ে যাবে। First point কি? Accused was being questioned under caution. Caution দিয়েছে না? Definitely. Accused was at the time was at an authorized place of detention. Definitely. Police station কিন্তু interview হচ্ছে। The accused was not denied access to solicitor. Solicitor ছিল। Accused failed to mention facts when questioned which he could have been reasonably answered. So look, accused কে বলা হয়েছে where were you? সে তখন কিছু বলে নাই, পরে কি বলছে, আমি বাসায় ঘুমাচ্ছিলাম। সো আপনার তখন এটা বলা উচিত ছিল না যে আপনি যে ঘুমাচ্ছিলেন বাসায়। That's the fourth requirement. Finally, accused later relied on the fact in his defense. পরে কি বলবো, যে আমি আসলে হোটেলে ছিলাম না, আমি আসলে বাসায় ছিলাম, ঘুমাচ্ছিলাম। সেই যে these 5 criteria satisfy, এজন্য আমাদের section 34 prove হয়ে যাবে। section 34 prove হলে কি হবে? You can draw adverse inferences against the suspect. So the conditions are satisfied. এই কতগুলো এই প্যারাগ্রাফের সাথে বলা আছে, এটা আমরা দেখলাম না। Now, why was he staying silent? Because of his solicitor. Read. Solicitor will have to say why. Was there a good enough reason why he asked his client to stay silent? So ও যদি এমনি বলে চুপ থাকো, তাহলে কিন্তু হবে না। He must have a good reason why he asked his client to stay silent. Or reliance on solicitor's advice, ওটাকে অটোমেটিক্যালি প্রিক্লুড করে ফেলে, ইনফারেন্স ড্র করা যাবে, এটা বলেই ফেলে না। সলিসিটরের উপর ডিপেন্ড করলেও ইনফারেন্স ড্র করা যাবে। So or solicitor ওকে বললো, একটু বুঝেন, this is a critical part. Or his solicitor said stay silent. He believed in it and he also thought, okay, this is good for me because if I'm staying silent I don't have to speak against me. So আমি যে guilty ওটা বের হয়ে আসবে না। So did he reasonably rely on this advice? No. So আপনি যখন না বুঝে একদম genuinely আর reasonably আপনার solicitor advice এর উপর rely করবেন, একমাত্র তখনই that is a good cause as to why I may not draw inference. Other than that, solicitor's advice, although a significant factor, but does not decide or does not preclude inferences to be drawn. Now, remember we started section 78. What is section 78? Judiciary's exclusionary discretion to exclude what sort of evidence? Prosecution evidence. Inferences from silence, কোন ধরনের evidence? Prosecution evidence নাকি defense evidence? কাকে favor করে? Infer যদি করি আমি defendant silence কে guilt, কাকে favor করে? Prosecution. সেই evidence কে পেশ করতে চাইবে? Prosecution. So prosecution evidence যদি একটা trial কে seriously jeopardize করে দেয়, would have such an adverse effect on the fairness of the proceedings that it ought to be excluded. তখন কি করে দিব আমি? জুডিশিয়ারিজরা তার নিজেদের এক্সক্লুশনারি ডিসক্রিপশনে সেই এভিডেন্সটা বাদ দিয়ে দিতে পারবে। রিমেম্বার? গুড। সেম প্রভিশন একটু ঘোরানো ল্যাঙ্গুয়েজে ছিল কোথায়? কমন লতে। সেই ল্যাঙ্গুয়েজটা কি বলেছিল? ইফ দি প্রোভেটিভ ভ্যালু is outweighed by the prejudicial effect. Probative value outweighed by the prejudicial effect. তখন কি করব আমি? ওই এভিডেন্সটা আমি বাদ দিয়ে দিতে পারবো। কে? জুডিশিয়ারিজরা বাদ দিয়ে দিতে পারবে। Finally, judge must give jury a direction. Although inference draw করা যায়, inference draw করতে হবে এমন কোনো কথা নাই। এক, although inference draw করা যায়, সেই ইনফারেন্সের বেসিসে তুমি বলতে পারবে না ও guilty. Although inference draw করা যায়, inference draw করা উচিত না, কারণ ডিফেন্ডেন্টে কি আছে? রাইট টু রিমেইন সাইলেন্ট। এই রাইট টু রিমেইন সাইলেন্ট হাজার হাজার বছর ধরে চলে আসছে বিকজ অফ প্রিজাম্পশন অফ ইনোসেন্স এন্ড প্রিভিলেজ এগেইনস্ট সেলফ ইনক্রিমিনেশন। এন্ড ডিফেন্ডেন্ট না চুপ করে থাকার কোনো কেস প্রুভ হয় না, বিকজ কেস প্রুভ করতে হবে কার? প্রসিকিউশনের। এন্ড প্রসিকিউশনের কত কোন লেভেলে গিয়ে প্রুভ করতে হবে সেটা? বিয়ন্ড রিজনেবল ডাউট। সো আপনি একজন চুপ থাকলো, লেটস সে ফর এক্সাম্পল I ask A, did you commit murder? He stays silent. A, did you rape someone? A, did you steal it? He stays silent. Now, you can think he did it, but do you have doubts? So ও চুপ করে আছে, ও চুপ করা থেকে ধরে নিচ্ছে মনে হতে পারে ও করতে পারে, but do you have still doubts? So if you have doubts, is the criminal burden of standard met? Because the case must be proved beyond reasonable doubt. So silence এখানে এমনিতেও আপনি পাচ্ছেন না। So কোনো এভিডেন্স নাই, ও চুপ করেছিল, খুব অবভিয়াস অ্যানসার্স তার বলা উচিত ছিল কিন্তু তাও সে বলে নাই। কিন্তু ওই না বলার বেসিসে আপনার কি সব ডাউট চলে গেছে যে ওই করেছে? ইউ স্টিল উড হ্যাভ ডাউটস। একদম চুপ করে থাকলে অ্যানসার দিলে না হতো, ঠিক আছে? কেউ যদি বলে হ্যাঁ আমি করছি, কনফেশন, তখন বোঝা যাচ্ছে করেছে, তখন আর তো ডাউট থাকবে না। কিন্তু সাইলেন্ট থাকলে তো স্টিল देयर ইজ দিস ডাউট, তাই না? সো ওই ডাউট থাকলেও আপনি তো ক্রিমিনাল বার্ডেন স্ট্যান্ডার্ড প্রুফ তো মিট হচ্ছে না, এইজন্য কি হচ্ছে না? কেস প্রুভ হচ্ছে। এইজন্য বলছি যদি ওইটার বেসিসে সো যদি কনভিকশন দিয়ে দেয়, দ্যাট মাইট বি ডেঞ্জারাস। So problem question দেখেন human rights এর ইস্যুটা কিভাবে লিখতে হয়। The right of silence is a central aspect of the right to fair trial secured by Article 6 of the European Convention of Human Rights. And consequently, a conviction should not be based exclusively or mainly upon accused silence. This is how you introduce HRJ concept, HRJ দুই তিনটা প্যারাগ্রাফ লিখতে হবে। This is how you introduce, and then you bring on যে Murray, Condron, ওই কেসেস গুলো নিয়ে আসবেন, জাস্ট কয়েকটা প্যারাগ্রাফ জাস্ট লিখে দিলেই হয়ে যাবে। Now, this is a very important line. Check this out. Adverse inferences, can it be drawn? Yes. But what do judiciaries follow? Certain special filter mechanisms, certain checkpoints. So one of the filtering mechanisms is that they give a warning. To whom? To the jury. The co-on directions and those directions. Did they warn the jury? Look, সাইলেন্সের বেসিসে সোল কনভিকশন করুন। সো ওই ডিরেকশনটা দিয়ে যদি জুরি অ্যাডভার্স ইনফ্লুয়েন্স ড্র করে তাহলে কি হিউম্যান রাইটস এর ব্রিচ হলো নাকি হলো না? ডিরেকশনটা দেওয়ার পর জুরিদের মতো ধরে নিয়েছে না এখানেও আসলেই ঝামেলা ছিল ডিফেন্ডেন্ট, এই জন্য সে অ্যান্সার দেয়। আমি কিন্তু আমার রোল আন্ডার এইচআরএ আন্ডার সেকশন 6 পারফর্ম করেছি। আমি বলেছি আমি কিন্তু হিউম্যান রাইটস কম্প্যাটিবল ওয়েতেই পারফর্ম করছি। আমি বলছি না যে ডিফেন্ডেন্টের রাইট টু ফেয়ার ট্রায়াল আছে, তুমি বারবার চেক করো, তোমার বিয়ন্ড রিজনেবল ডাউট হচ্ছে, সবকিছু আমি বারবার দেখছি না। তো তখন আমার কি কোর্টের যে ডিউটি ওটা হয়ে গেছে না স্যাটিসফাইড? সো তখন কি হিউম্যান রাইটস ভায়োলেশনটা হচ্ছে নাকি হচ্ছে না? মেবি হচ্ছে না, because I've given a direction. এখন জুরি যদি তাও মনে হয় আমি কি করব, জুরিকে তো আমি কন্ট্রোল করতে পারবো না, জুরিকে তো আমি বলতে পারবো না তুমি এখানে ডিফেন্ডেন্টের গিল্ট ফাইল করতে পারো, এটা বলতে পারবো আমি? এটা বললে তো তখন উল্টা প্রসিকিউশন অ্যাপিল করবে পরে যে কি করতেছে জাজ, তাই না? আমার যতটুকু করা দরকার ততটুকু কিন্তু আমি করে দিচ্ছি। আমার অ্যাজ এ ম্যাটার অফ আমার অ্যাজ এ জাজ আই কুড হ্যাভ জাস্ট গিভেন হিম আ ওয়ার্নিং। আর যদি জাজে যদি খুব বাজে লাগে এভিডেন্সটা যে খুব প্রেজুডিশিয়াল একটা ইফেক্ট ফেলবে, সে কি সেকশন 78 এবং কমন ল আন্ডারে কিন্তু সেটা জুডিশিয়াল ডিসক্রিপশন অ্যাপ্লাই করে বাদ দিয়ে দেওয়ার একটা তার অপশন থাকে। Failure to direct the jury properly in relation to the nature of the circumstances in which inference may be drawn may result in violation of Article 6 of European Convention of Human Rights. এখন আপনি যদি ডিরেকশনও না দেন তাহলে ডিফেন্ডেন্টের রাইটস কিন্তু ভায়োলেট হচ্ছে। মানলাম আপনি এক্সক্লুশনারি ডিসক্রিপশন এন্ড এভিডেন্সটা বাদ দিলেন না, সো 78 অ্যাপ্লাই করে বা ওই যে কমন ল অ্যাপ্লাই করে আপনি বাদ দিলেন না এভিডেন্সটা, কিন্তু আপনার তো একটা ওয়ার্ন করে দেওয়া উচিত ছিল জুরিকে যে look, I have the right to remain silent, burden of proof prosecution of course standard beyond reasonable doubt, আমার presumption of innocence আছে, আমার right against self incrimination আছে, adverse inference draw করা যাবে না, draw করা গেলেও adverse inference solely বা mainly based করে তুমি conviction secure করতে পারবে না, এগুলো তো বলে দেওয়া উচিত ছিল, রাইট? এগুলো যদি না বলে দেন তখন কি হয়ে যেতে পারে, আর্টিকেল 6 এর ভায়োলেশন হয়ে যেতে পারে। ক্লিয়ার? What was question number B? What's the time? Is it 4:47?
Yes.
Okay. What was question number B? Which is David's failure to answer question during the second interview. Second interview তোকে কি কি জিজ্ঞেস করেছিল মনে আছে? Remember? Second interview তোকে জিজ্ঞেস করেছিল তুমি ক্রাইমের সিনে প্রেজেন্ট ছিলা কিনা আর তোমার বাসায় এগুলো কেন পাওয়া গেল। সো বাসায় এগুলো কেন পাওয়া গেল ওখানে কোন সেকশন? সেকশন 36। আর তুমি ক্রাইম সিনে প্রেজেন্ট ছিলা কিনা এটা কোনটা? সেকশন 37। লোক ওই যে পজেশনটা বলেছিলাম না যে ওই যে তৎক্ষণাৎ পেতে হয় এট দি টাইম অফ অ্যারেস্ট, সেখানে কিন্তু ওখানে পায়নি, ওর বাসায় পেয়েছিল। সো এই পজেশনটাকে যদি আপনি ন্যারোলি ইন্টারপ্রিট করেন এটা পজেশন নাও ধরা হতে পারে, কিন্তু যদি আপনি ওয়াইডলি ইন্টারপ্রিট করেন ইট মে স্টিল বি পজেশন। প্রত্যেকটা জায়গায় বলবেন সাইলেন্সের পর যে কন্ডিশনস গুলা, এই কন্ডিশনস পড়ার দরকার নেই বিকজ উইভ লুকড এট ইট, রাইট? You able to do it. Do you have to repeat the conditions of section 36? Fine. There are like 5 conditions, right? Good. And after each of this section, you just make sure that you write this part. There must be a direction given, and the direction part গুলো বলবেন। যে ইনভেস্টিগেশন থাকবে, কশন করবে, ওই যে ওয়ার্নিংস গুলোকে একটু ফ্যাকচুয়ালি অ্যানালাইজ করবেন। কোয়েশ্চেনিং কিন্তু থাকবে না, কোয়েশ্চেনিং কিন্তু পুলিশ অফিসাররা কি বলছে না বলছে ওগুলো কিন্তু থাকবে না, ঠিক আছে? সো ওখানে আপনি একটু ভেঙে লিখবেন যে এই টাইপের কথা বলা উচিত ছিল কোয়েশ্চনে। It's a matter of fact for the jury to decide যে এই টাইপের কোয়েশ্চন দিয়েছে কিনা, it's a matter of fact for the judge to decide যে ওর ডিরেকশন দিবে কিনা বা এটা কি অ্যাডভার্স ইনফ্লুয়েন্স ফেলছে কিনা। যদি অ্যাডভার্স ইনফ্লুয়েন্স ফেলে ওই such an adverse influence on the fairness of the proceedings that it ought to be 78 অ্যাপ্লাই হবে কিনা, কমন ল অ্যাপ্লাই হবে কিনা, এগুলো কিন্তু প্রত্যেকটা ওয়ার্ড করে লিখবেন। এখানে এ বি ছিল দেখে বারবার লিখতে হচ্ছে। আমার যদি পুরোটা একটা কোয়েশ্চেন থাকে যে ইউনিভার্সিটি প্ল্যানের যে কোয়েশ্চেনগুলো হবে তখন কিন্তু বারবার লিখতে হচ্ছে না। ওকে ওভারঅল একবার লাস্টে গিয়ে হিউম্যান রাইটস এর কথাগুলো আর ওয়ার্নিংস এর কথাগুলো লিখে দিবেন আর জুডিশিয়াল ডিরেকশনের কথাগুলো লিখে দিবেন। সি কি ছিল? সি ছিল যে ডেভিড যে কোর্টে এখন এসে কথা বলতে চাচ্ছে না, সো ইটস একদম লাস্ট স্টেজে এসে এখন সে চুপ থাকতে যাচ্ছে। ক্যান ই ডু সো? ইয়েস, বাট ওটা কি এক্সেপশন আছে? আছে। সিজেপিও কোন সেকশন? সেকশন 35, যে কোর্টে চুপ থাকলে অ্যাডভার্স ইনফারেন্স ড্র করা যাবে নাকি যাবে না। Section 35 is obviously অনেক detailed. এটা এই লেকচারে আর কভার করা যাবে না, it would take half an hour for me to go through section 35 requirements, but obviously I don't need to do that. So we have finished confession and silence, which is a major or significant portion of the syllabus. ঠিক আছে? We have solved questions, we have also looked at the essay angles. Make sure when you study you also keep in mind the concept of section 78 exclusionary discretion. common law exclusive discretion. So you people make your own notes. আমি তো অনেক কিছু handout provide করে দিয়েছি. So when you study, make your own notes. একটা বানাবেন just section 78 এর উপর 2 থেকে 3 পেজ. Just make some notes on section 78 কখন prosecution evidence exclude করে ফেলতে পারে judgeরা, right? আর সেই provisionটা similarly আগে কিভাবে প্রযোজ্য ছিল common lawতে এটাও দেখে ফেলেন। আর যখন confession and silence দেখবেন, you obviously first go through the statute and then supplement it with case laws. So in case you find it difficult to understand any concept, just fix an appointment with me. Just give me a call. I'll come at one day যেখানে সবার প্রবলেমস গুলো দেখে ফেলবো। সো আমরা সলভিং কিন্তু মোটামুটি আমরা বার্ডেন স্ট্যান্ডার্ড থেকে তো ওরকম প্রবলেম কোয়েশ্চেন তো আসে না। সো প্রবলেম কোয়েশ্চেন আসলেও যতটুকু পড়েছি ইটস এনাফ। এসে কোয়েশ্চেনের জন্য কিন্তু পড়েছি। সো উইভ কভার্ড বার্ডেন স্ট্যান্ডার্ড প্রুফ, judicial direction to the jury, confession and silence. So we've covered a significant portion. It's time for you people to now study and check whether there are problems at places or at chapters which I might be able to help you out with, and start preparing notes. So obviously if you find my notes to be too elaborate, you shorten them down and you make a concise version for your exam preparation. I will be providing this solving or the confession. Do you need the slides of the confession?
Yes.
Did you not copy them during the class? Or should I give an elaborate note on confession or a shorter version?
So short note our library usually very easy.
Achha, fine. So I'll give you a shorter version of the confession note, and I'll provide the soft copies of the silence concept that we did. So obviously we covered section 34, section 35, section 36, and section 37. Also we looked at the common law exceptions of drawing inferences against defendant silence, and the notes will be provided on the page. So keep an eye on the Facebook page and start studying. We have only got like 3 months left, so definitely start studying, and it shouldn't be a problem. Evidence is okay, I guess. What about the other chapters? We stop our today's class